Hello, my name is Gene Fraser, a litigation lawyer with CBM Lawyers Estate Litigation Group. In this video, I'll describe some important issues to keep in mind when considering how to protect and pass on what is often your most valuable asset, your house. When we experience the excitement and accomplishment of buying a house, we don't often think about the ramifications of ownership and death. But your house may be your most valuable asset in your estate. In order to try to minimize the financial impact of eventually transferring that asset on death, people often consider sharing ownership of their house with adult family members or friends. Shared ownership can apply to such things as bank accounts or motor vehicles, but there are particularly serious implications to consider when doing so with a house. Two of the most common forms of shared ownership of houses are tenancy in common and joint tenancy. Tenancy in common is when two or more people hold a separate interest in property, which may not necessarily be in equal shares. For example, you could gift a 1/3 share in the house to one of your children. Then if one of the shareholders die, only their share gets transferred to their estate and distributed to their beneficiaries. Another option is joint tenancy, where each person owns an equal share of the property. In the case of a couple, let's assume each will get a 50% share. When one dies, the other has a right of survivorship and gets 100% of the house without the asset passing into the estate. Therefore, beneficiaries of the estate would not receive a share of the value. While this is a common occurrence, joint tenancies require complicated and exacting documentation. Don't assume that every lawyer or notary is capable of drafting such an agreement that will hold up in court. Joint title can be broken or severed in a number of ways, including mutual consent of the parties or by the unilateral action of a joint tenant. In fact, a joint tenancy can even be severed without your knowledge or consent. If this occurs, you could lose the right of survivorship in their share of the property. That means that if you die before they do, then their interest in the property would pass to their estate and would be divided among their beneficiaries. There are important differences between having legal title to a property and simply having a beneficial ownership in a property. To have a legal title, you must be registered as a co-owner of the property with the Land Title Office. It's not sufficient to have a letter or napkin with a promise of ownership on it, even if you've paid something for the right. Also, the courts may not consider you a real owner if you did not pay for that ownership. This type of situation can arise when the owner of a property transfers legal title to another person, thereby creating a joint tenancy only for the purpose of avoiding probate or to manage an estate, but with no intention to give the other person any beneficial or real ownership of the property. It's important to have properly prepared documents confirming the owner's intention in creating shared property arrangements. For example, if the owner of a house creates a joint tenancy with another person only for the purpose of managing the house or avoiding probate, then this should be confirmed in a document that both parties sign. This document may then be used to reverse the severance of a joint title if the new joint tenant attempts to do that unilaterally. If the owner of a house intends to give another person both legal and beneficial ownership of the house, it would be prudent to sign a deed of gift that sets out the owner's purpose for that transfer clearly. This deed of gift could then be used as evidence against claims that the new joint tenant is only holding legal title in trust for other parties. For more information, please contact one of the Wills and Estates lawyers at CBM Lawyers. If you feel you're in a situation where your legal involvement in a house might be unclear, feel free to give me a call.